Welcome to Castrip, where real courtroom drama meets shocking twists. From explosive testimonies to judges dropping bombshells, we break it all down. Subscribe at OIT.
Good morning, Mr. Huddleston. Sir, you're charged with tampering with a government record. You were facing up to 6.
Hold up, 6 months in jail for a tag. Sounds petty until you realize this is not about paperwork. It's about intent. If you knowingly use a fake government doc, that's fraud. And in Texas, that's a fast track to handcuffs.
Months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, will be appointed to you, sir.
On February 16th, officers observed a vehicle with a temporary tag which came back with no return. A traffic stop was conducted. The defendant was the driver and sole occupant. The defendant stated he knew about the tag and had been pulled over the week prior. The defendant stated his mom went to the dealership and brought a new buyer's tag for the car. The defendant did not know how much the new tag would cost for.
So why does Mr. Huddleston get charged then? Oh, it's pled differently. It's pled differently. That's why. Let's see. It's pled here as use as opposed to purchasing. And I think that's why. So let me see.
And I did notice it showed up as tampering with the record insurance document, but it looks like on the complaint it is tampering with the doctor's record.
Hereinafter, style the defendant heretofore February 16th did then and there unlawfully, intentionally, and knowingly use a governmental record, namely Texas temporary tag, attached hereto as Exhibit A, with knowledge of its falsity. So one of the parts is it says with knowledge of its falsity.
This is where it gets legally spicy. The whole case hinges on knowledge of falsity. Did he know the tag was fake, or was he just clueless? That single detail can flip this from a mistake to a crime.
Falsity.
Yes, Judge.
Does he know of its falsity?
Well, upon the officer approaching the vehicle,
Okay.
he knew immediately what the traffic stop was for. That he'd been pulled over the week prior. That's it.
He had been
Yes.
and advised that it was no good. Just read it one more time.
Officers observed a temporary tag which came back with no return. A traffic stop was conducted. The defendant was the driver and sole occupant. The defendant stated he knew about the tag and was
Okay.
pulled over the week.
Right. Okay. All right. Mr. Huddleston, I'm going to find that there's probable cause to go forward with your case. Can you run his license? See if he has a valid Texas license, please. I am ordering you as a condition of your bond, sir, not to drive any vehicle unless you have a valid Texas driver license and liability insurance in your name. Do you understand?
Yes, sir.
These are your bond conditions, meaning that if you don't follow these bond conditions, a warrant for you.
That's a hardline warning from the judge. No more personal recognizance, bonds meaning no walking out without cash or a co-signer when you are already on felony, probation, and rack up new charges. The system stops playing nice.
The rest will be issued. You will go to jail. No more PR bonds. What's more is you are on felony probation. You've not picked up a new case. That's beyond the lookout. It's very possible that they now issue a warrant.
His license is valid. Judge.
So you mind filing that then? No driving with that both, please. Tell me, Mr. Huddleston, do you have the ability to hire a lawyer?
Well,
I'll have you fill out an application. I'll take a look to see whether you qualify. All right? Do not leave until you sign our bond conditions. You understand? Come on. Mr. McGee, I mean, I don't even know what happened, but I'm in shock, man. You're on deferred for an unauthorized use of a motor vehicle. Since January, you picked up a failure to ID, an evading arrest, 2 theft cases, another evading arrest, another UUMV, and
Awaitate open cases. This man's court calendar looks like a Spotify playlist of charges. Evading theft, burglary, it's not looking good for our guy. And the judge, you can tell he's done playing babysitter.
we have
whoa. Oh, excuse
Hold
me.
on.
Sorry.
We're going to do probable. I have no idea what happened. We'll do probable cause on all of them because I have no idea. All I know is that you've got 1, 2, 3, 4, 5, 6, 7, 8 open cases. So let's do this. I see. So far, from January 23rd of this year, he had a failure to ID evading. We've already done probable cause. It's been found that there's a bond set. It looks like February 14th, a felony theft was picked up. A bond has been set on that case. Probable cause has been found. Now, as of 2:15, the next day, you picked up a theft, evading arrest, another unauthorized use, and a burglary of a motor vehicle. So we're going to do probable cause on all those cases. You have the right to remain silent. Anything you say can or will be used against you. So I guess, can you start with the theft?
Yeah.
So in this case, you're facing up to 6 months in jail and or a $2,000 fine.
On February 14th, 2025, officers were dispatched to 6955 Sam Houston Freeway regarding a shoplifter. The call note stated that a black male wearing blue jeans and a brown jacket was inside the store concealing items. The officer observed the defendant walking outside the location and through the parking lot. The officer attempted to make contact with the defendant, who then began to flee on foot. The defendant ran through the parking lot, maneuvering through motor vehicles. The officer was then able to catch up with the defendant and attempted to tackle the defendant to the ground. The defendant was able to slip away and continue to evade. The officer was able to tackle the defendant to the ground, but was still attempting to stand
The theft from Target. And not just that, he bolts through a parking lot, dodging traffic like it's a Fast and Furious audition. But here's a question. Is a $30 theft worth a resisting arrest charge and a beatdown from an officer?
back up and get away. So the officer struck him one more time to gain compliance, and he evaded for approximately 50 yards.
Where was that theft from?
Target, Your Honor.
All right, so I'll find probable cause on both of those cases. So then we have now a burglary of a motor vehicle from 2/19/25. What happened then?
On December 25th, 2024, officers were dispatched for an abandoned stolen vehicle at the Cypress Park and Ride. The officer reviewed surveillance footage taken from December 25th, 2025, and observed the complainant's vehicle. The officer identified a black male wearing a hoodie, blue jeans, and brown boots entering the vehicle. The officer immediately recognized and identified the defendant, identified as Zyron McGee, also known as Zion Williams, from a previous case at the same location. The defendant in the video, he then broke the window and got into the vehicle. The complainant did not give the defendant permission to be in the vehicle and was missing a jacket and a charging cord.
Did you say all that was on video too?
Yes, on the surveillance.
The other thing you said, it happened December 25th
Yes.
of 25 or 24?
24.
So it seems, okay. So I'll find there's probable cause to go forward there. So what, we need to set bonds on these cases. What should we set them at?
Well, of course, defendant is 18 years old, judge, no job. Are you in school?
No, man, I'm supposed to go back to school. They, two of my schools didn't allow me because of my charges of the summertime.
And this is where the courtroom breaks your heart. He's only 18, no job, no school, supposed to graduate, but the system and maybe his own choices have him caught in a loop. You have to wonder, is this justice or just another lost kid in a cycle no one's breaking?
I'm in 2024, and they denied me school.
What grade are you in?
I'm supposed to be 12th grade. I'm supposed to be graduating this year.
I see one thing. That's what I see.
Yes, sir. But
It's the only thing